All right, I think it's going to the chapel, and we're going to get married, Claude, for the next hour opener. Marriage songs, anyway. We are delighted to be joined by our old friend David Rivkin. He is a partner at Baker Hostetler, one of the top law firms in the country, actually. He's a former member of the Justice Department and the White House Counsel's Office in both the Reagan and George H.W. Bush administrations. Morning, David.
Great to be with you.
Thank you. Give us your overview. What kind of a day was it? If you were for traditional marriage, if you were for gay marriage, who's feeling better this morning?
I would say that the proponents of traditional marriage are feeling better, but particularly I would say not just proponents of traditional marriage as a compelling policy decision, but the proponents who view it however you come out on this issue, it should not be decided as a matter of a constitutional imperative by the courts. A couple of points in this respect. First of all, I have never seen, certainly in recent times, an argument where liberal justices were that discomfited by the notion of giving the progressives what they want. Lots of musings about the problems posed with a 50-state one-size-fits-all solution in favor of same-sex marriage, including, again, justices like Kagan, Sotomayor, and Ginsburg. Lots of musings, primarily from liberal justices, about possible standing problems, the fact that cert probably should not have been granted. So that tells me that they're very unsure whether or not there is, and it's not unusual, 5 votes on their side. But aside from that, again, a real palpable concern about hijacking this issue judicially and dealing with it more or less in the same manner that the court dealt in infamous Roe versus Wade abortion case.
This is very interesting. Let me repeat my own words. Correct me if I'm wrong. You're saying you cannot recall ever seeing liberal members of the court so discomfited by arguments made by progressives before them.
Correct.
Wow.
Visibly discomfited.
Yeah. Go ahead.
I'll give you one example.
Yeah, please, go ahead.
At one point in time, musings from a couple of liberal justices, but even when it came to Brown v. Board of Education, a famous civil rights case, they did not sort of jump on it, and this issue immediately they gave time for the issue to percolate. The timing, the precipitous manner, if you will, in which the proponents of a judicial mandate for same-sex marriage are driving it, just clearly gives them discomfort.
Is this one of them? Well, let's play cut number 5 and see if this is an example of what David's talking about, or if he'll otherwise comment on it. This is Justice Sotomayor and Ted Olson.
Mr. Olson, the bottom line that you're being asked, and it is one that I'm interested in the answer. If you say that marriage is a fundamental right, what state restrictions could ever exist? Meaning, what state restrictions with respect to the number of people, with respect to that could get married, the incest laws, the mother and child, assuming that they're the age. I can accept that the state has probably an overbearing interest on protecting a child till they're of age to marry. But what's left?
Well, you've said in cases decided by this court that the polygamy issue, multiple marriages, raises questions about exploitation, abuse, patriarchy, issues with respect to taxes, inheritance, child custody. It is an entirely different thing. And if a state prohibits polygamy, it's prohibiting conduct. If it prohibits gay and lesbian citizens from getting married, it is prohibiting their exercise of a right based upon their status. It's selecting them as a class, as you described in the Romer case and as you described in the Lawrence case, and in other cases, you're picking out a group of individuals to deny them the freedom that you've said is fundamental, important, and vital in this society, and it has status and stature, as you pointed out in the VMI case.
Is this an example of what you're talking about?
Here's an example, and it's funny you mention this because, as I said, I was, not to be presumptuous here, but I was stunned by Sotomayor's question because it goes to the heart of the problem with a judicially compelled, which is to say constitutionally compelled marriage. Olson's answer was, of course, singularly unsatisfactory. Let me just elaborate because it really goes to the heart of both sort of equal protection argument and the liberty aspect of a due process. And it's not just about protection of children, of course, child rearing in the context of traditional marriage. It goes to the very survival of marriage. as a social institution, as a viable institution. Let me explain. If you have a political decision to recognize same-sex marriage, as all political decisions, incremental, and it's done one thing at a time. So you could decide to recognize same-sex marriage, but you can deny, for example, recognition of polygamous marriages or polyamory, which is multiple men and one woman, or you can recognize some other arrangements. In my personal favorite, because it doesn't seem to be sort of so radioactive in our popular culture, why not marriage for a term of years? You have two people coming forward and saying, we love each other now, but we don't believe till death does it do us part, and we want to be married for 10 years. What's the possible basis for denying us our happiness? So if you decide marriage...
That's very interesting. Yeah, go ahead.
If you decide marriage is a political matter, Bill, you can satisfy the same-sex marriage claimants, but pull up a letter and say no to everybody else. If, on the other hand, the marriage is constitutionally compelled, and the sole reason it's the case is because you have two adults or multiple adults, and the personal desire for self-realization, for joy, for happiness is all that makes it constitutionally obligatory. And there's no, and this is what Sotomayor, I think, was troubled by. There's no basis to deny all those other permutations. And let me say it as crisply as I can. If every conceivable arrangement involving adults is marriage, then there's no marriage. And the society has enormous interest in preserving the long-term viability of a social institution, because I think we could all agree, however you come out in gay marriage, the society where marriage means nothing is not a great society.
Okay. When I used to argue this, I remember arguing this with Andrew Sullivan on TV, I would always say, well, why not 3? And he'd say, because that's not marriage.
Really? Not under, I was going to say, really not under the definition of marriage being propounded by the proponents of opponents of Opposition 8, because, again, they say, look, we have this research which says it's not bad for children, but in any case, marriage is not about children. Marriage is about keeping people happy. And one more thing, not to be kicking poor Ted too much, the reason his answer is so obviously unsatisfactory is because unless you, once you take the children up and minors off the table, why is it exploitation for free people to be married?
Yeah.
And if you have, which of course most horrifies most people, but if you have an incestuous marriage, brother and sister, where's exploitation? Where's patriarchy? In any case, patriarchy is a value judgment, and the whole point of people who are pushing against traditional marriage is majority has no right to impose this value judgment on me. I want my personal happiness. I want to marry my same-sex partner, and you have no right to stand in the way. And again, it's constitutionally compelled. That's what Sotomayor was getting at. And let me segue to my other favorite case, which you and I talked a lot about, which is Obamacare. The biggest problem people have here is the same one in Obamacare. There's no cabining principle. There's no judicially enforceable cabining principle that if you give the proponents of same-sex marriage what they want as a constitutional matter, that you can stop other claimants who would want marriage further redefined for their benefit.
Right. Okay. Let me just see if I understand a part of this. Is she saying, in effect, look, the states restrict in several ways. By your argument, the state wouldn't be able to restrict at all?
Correct.
Okay.
And help me. I mean, that's sort of the highest form of oral argument where somebody is asking you to reassure them, to remove this, to basically saying, look, I would like to help you. I would like to rule with you. I'm obviously reading things into it.
Yeah,
but give me some answer that would reassure me as to what this cabining principle, what the limiting principle here would be. And, of course, he utterly failed, and it's not because he's a bad lawyer. He's actually a very good lawyer, because there is no cabining principle.
Yeah. Could they have defined it another way? Could they have said the constitutional right to marry a person of the same sex is? Could they have cabined it? Could they have had a cabined definition?
If you decide now that the same-sex marriage is constitutionally compelled, in the process of deciding that, you really cannot come up with a cabining definition. Because, again, what you're doing is, and it's not just marriage, you have come up with a new principle that every time 2 or more adults really, really want something badly and feel that it's necessary, the realization of their inner aspirations.
Yeah.
Remember the language from cases like Casey and Carhart about the inner mystery of me. It's the state. Let's forget about the state.
Yeah.
We're really talking about the people.
Yeah.
This is a question of political society from a democratic processes. imposing its value judgment.
Okay.
And the answer is you cannot do that. Well, if you cannot do that, you cannot do it with a whole variety of issues.
You can't do it for sex, gender. You can't do it for number. You can't do it for relationship. You can't do it for a lot of
and again, marriage probably, not to be flippant about it, marriage for a term of years would be very difficult. If I have our argument, I would say, look, you allow now no-fault divorces. So obviously people are not
20 seconds, David. 20 seconds. Go ahead.
And why should we not be able to be married temporarily? Because we don't have to want to go for divorce when a marriage automatically expires.
Okay. We'll be back. David Rivkin will stay with us. He'll take your calls. This is a great opportunity if you've had questions. 866-680-6464. 866-680-6464. This won't be the last time that we have David Rivkin. I was saying to our guest, David Rivkin, who's a partner at Baker Hustetler, used to work in the Justice Department, the White House, and Reagan Bush, that one of the saddest days of my life, punctuated by the only joy was having him on, was the day after the Supreme Court decision where John Roberts decided Obamacare was constitutional. The only bright spot of that day was David Rivkin's analysis. Delighted to have him back. David, calls are starting to come in. One of the arguments I've been making all week is kind of unusual for me. I'm a philosopher. I tend to think of the timeless truths, but I said, we don't know enough. We don't know enough yet. Is there enough data? Alito asked this of the who are they? The respondents yesterday. Let's play Justice Alito and get David Rivkin's comments.
So one thing that the parties in this case seem to agree on is that marriage is very important. It's thought to be a fundamental building block of society and its preservation essential for the preservation of society. And traditional marriage has been around for thousands of years. Same-sex marriage is very new. I think it was first adopted in the Netherlands in 2000. So there isn't a lot of data about its effect. And it may turn out to be a good thing. It may turn out not to be a good thing, as the supporters of Proposition 8 apparently believe. But you want us to step in and render a decision based on an assessment of the effects of this institution, which is newer than cell phones or the Internet? I mean, we do not have the ability to see the future.
Reasonable argument, David?
Perfectly reasonable argument, and goes again to the heart of the merit question, which is, was it rational if you assume the deferential level of scrutiny? Was it rational for the citizens of the state of California to say no to gay marriage? And even if it's a matter of heightened scrutiny, it goes to the question of how clearly compelling is the state interest. And what Alito is saying, in a situation, think about it, in a situation where you have enormous amount of what's at stake, and the evidence is ambiguous, caution, prudence, not rocking the boat is the right answer. And that, of course, is also an argument against the one-size-fit-all solutions by the judiciary at this time. So it's an excellent question.
Okay, an excellent question and an excellent concern. This is a short segment. We have a longer segment coming up. It's very early, we have another day of hearings. Would you, based on what you said in the opening, you hadn't seen such antipathy on the part of the liberals toward progressive arguments. Would you fancy a guess at this point as to what they'll do? Always risky.
Always risky for more arguments, but I would say that the decision that the proponents, that Ted Olson and David Boies and opponents of Proposition 8 want, which is declaring same-sex marriage as constitutionally compelled in 50 states, in my view, is very unlikely.
Okay. And what was this argument Verrilli made that suggested where they have civil unions, certainly, but maybe where they don't have civil unions? Ted Olson couldn't have been pleased with that argument, could he?
No, that was frankly a ridiculous argument. I hate to be so blunt here, but the government, which came here as an amicus, was basically arguing the following, that in a subset of states that bill have allowed same-sex civil unions it was irrational for him to deny same-sex marriages. The virtue of his argument, as he saw it and DOJ saw it, is would not impose solutions on all states. But it's just a ludicrous argument. The reason it's ludicrous is because, again, it reduces the marriage to solely one question, which is, look, if we are satisfied that the particular practical indicia of marriage can be granted in the civil unions without risk to children, leave it to well enough alone. There's no consideration to the other factors we've been talking about, which is legitimacy, whether or not you're deconstructing marriage towards an innumerable number of future claimants. Ridiculous argument was never embraced by anybody below, and it was frankly a waste of court's time.
True enough that if you deny respondents here, you could still create benefits for gay couples and others outside of marriage?
Yes, you can. I mean, SIDIC is able to get all sorts of entitlement programs and benefits quite aside from the framework of marriage.
Right, and does so all the time.
Does so all the time.
We'll be back with David Rivkin and your questions. This is terrific. What a great opportunity to learn. We'll be back. It's Morning in America. Stay with us.
Everybody's talking at me.
Everybody's talking. Everybody's listening to David Rivkin, partner at Baker Hostetler, Justice Department, served in the Justice Department, the White House Counsel's Office in Reagan, and then in George H.W. Bush administrations. David, I'm going to go to line 4, and I want to piggyback on this question. Ken is in Atlantic, Iowa. Go ahead, Ken.
Yes, my question is, will the Supreme Court ruling have any effect on states like Iowa where the courts establish gay marriage and there's not enough political clout to change it? For instance, we had a Democrat governor, Democrat Senate when it was established, and now we have a Republican governor, but we still have a Republican Senate, and we can't get it through the legislature.
You have states that have passed legislatively and by referendum, and then judges have come in and said no. How will the court's ruling impact there? It depends on what the ruling is, I guess. Huh?
Good question. If you have state legislature that pass statutes or constitutional amendment that legalizes same-sex marriages, or a state court decision that predicates that result upon state constitution, what the Supreme Court will do in this case would not have much of a bearing. If, on the other hand, state courts, which of course have to apply federal law and the Supremacy Clause, felt or concluded that the marriage is compelled because of the federal constitutional considerations, and the Supreme Court were to reach the merits here and ruled otherwise, those decisions would not stand.
Say that again. If the state court...
If the state courts have upheld the decisions not based upon state statutes or state constitution, but upon the interpretation of federal constitution, and the Supreme Court concludes that there is no constitutionally guaranteed at the federal level same-sex marriage, then those decisions would not stand.
Off the top of your head, if you can say so, most states, do their courts' interpretation, are they based on state law, state constitutions? Or
most of them, the ones I'm familiar with, are all based upon state constitution. So those decisions will survive whatever happens. But on the other hand, I think to the extent that there's no overarching dictate from the United States Supreme Court, that would liberate the citizens in various states who are unhappy with what happened. Look, this is what happened in California briefly. He had a state Supreme Court finding the right to same-sex marriage based upon California Constitution. And for those of you who may recall, Prop 8 was not just a statute bill. It was an amendment to the California Constitution. So you have an opportunity to continue debating those issues.
I got you. All right, so it stays alive. The issue stays alive. Similar question, I guess, if the court finds against a sweeping declaration for gay marriage, it could still throw it back to California and say it could still be a win, I guess, for the gay marriage advocates by saying what the people who had. How can they say the people who passed Prop 8 didn't have standing?
Well, it's it's not. First of all, I don't think it's a very compelling argument, even though we took some time yesterday. The argument is this. We typically have state officials defending the legitimacy of state administrative or legislative acts. Here, of course, they did not do so. Under California state law, however, there's a special provision that puts the individuals who initiated, Bill, the particular referendum in a special, unique position. And there was some debate about it yesterday. I think the argument that they don't have standing is a very bad one because, frankly, those individuals are not vindicating their own rights. Those individuals are really the agents of the state of California, and it's up to California in state law to determine who are its agents. But if there's a real division in the court, they can use the standing argument to punt. Very briefly, what that would do, it would certainly kill the Ninth Circuit decision. It may or may not, depending on how they slice it, kill the district court decision. So the worst-case scenario then would be either in California that all the decisions having to do with Prop 8, both district court and Ninth Circuit, go away, or the Ninth Circuit goes away, and Prop 8 has only been invalidated in the footprint of one district court. So this whole thing would have, an elephant would have borne a mouse. I'm mixing my metaphors.
Got it. Okay, other calls, tons of calls here. Let's go to Gene in Jacksonville. This is a question we've had all week. I don't know quite what to say to it. I think I do, but I'm going to let David answer. Go ahead, Gene.
Yeah, my question is, if the court rules that the gay marriage is constitutionally guaranteed, why not just, throw out marriage altogether and say, hey, look, this is a religiously instituted institution, and therefore, based on all the decisions that they make about separation of church and state, this is, not something that the government should be involved in, and there is no more governmental recognition of marriage. It's just if you want to go to your local church and your local church does marriages, you go and you do it. But
okay, get the state out of marriage.
There'll be a temptation to, in fact, withdraw. Let's be fancy and say indicia of state action or state participation in marriage. The problem with that in modern administrative states, so many things in a society pivot upon marriage: insurance, custody, inheritance, taxes. It would be, and then people would be, and this is what an issue in DOMA, of course, being argued today. If you created your own church, as some people do, and you can call it the church of polygamous marriage, and therefore people have been blessed in marriage by their church. What do? Does IRS recognize this marriage? Do you get a marriage deduction? And then there's so many other things in common law, for example. There's still a concept of spousal privilege, which is very important. If you're in a criminal case, you'll not be compelled to testify against your spouse. Well, if you're in a marital arrangement that majority finds jarring, but some church blessed it, to me, it would be another example of what I was talking about in an earlier segment, namely, if a court decides wrongly here, you would begin deconstructing marriage. It's sort of withdrawing marriage. And remember, marriage is a quintessentially social institution. It's not just a private institution.
Right.
So you start pulling it completely in the private sphere, it would not be the same marriage anymore.
Yeah, no, I think that's right. I think that's not a route we can go. Let's go to Francis in Greenville, South Carolina, our powerhouse station. Hi, Francis.
Hi, how are you this morning?
Good.
My question was, I've heard you talk about the continuum of sexuality, and then Mr. Olson is talking about that the right to marriage has been denied based on status. Is the court going to create a protected class here like race, and how can they do that when it's not immutable like race? I mean, I know it's a great debate about whether your sexuality can change or not, but certainly it can for everybody. Certainly it can for some people. And so I was and it brings up the question, would you have to be gay to have a same-sex marriage, and how are we going to define what gay is?
Right. The short answer is it's a good question. The proponents of same-sex marriage, of course, argue two things. First of all, your sexual orientation is immutable. It's sort of genetically imprinted on you. I'm not a scientist, but there are a lot of debates about it.
Yeah.
But second is that there is considerable animus towards gays. That, to me, easier to rebut, frankly. It's absurd. We now have a situation, very briefly, where public opinion has substantially shifted. 9 states plus the District of Columbia allowed gay marriage. The Democrat Party has gotten to the point now, including the president, where that's become an article of faith, not only gay marriage, but constitutionally compel gay marriage.
Yeah.
The Republican Party has shifted. If these are indicia of political powerlessness, I don't know what political power is. But the good question here, and this is, again, one of a collateral bad consequence of a wrong decision, the court has not recognized a new suspect class requiring a high level of scrutiny in decades. If you do that with gays, precisely because there's some doubt as to whether or not they're immutable and the extent to which they're subject to discrimination, you're basically opening the door to proliferation of multiple other classes. So every set of people, no matter how diverse they may be otherwise, who united by a common grievance would say, well, where's another suspect classification. And remember what it does. It dams the channels of democracy, because if you have heightened scrutiny of some decision by the government, which is to say by the majority, the court very likely is going to strike it down. So that's not a good thing.
If I'm just curious on the immutability argument, because I've read a fair amount in this, and I'm suspicious of the argument. My own view, based on what I've read, I hope fairly and objectively and dispassionately, is that there are some people who are born immutable characteristic and inclination to being gay. There are some who have experiences which get them there, and there's a large part of people in the middle, what Petullo at Harvard calls the waverers. But I'm not asking your opinion on that unless you have one, David. But if the immutability argument were to be taken apart or fall apart based on research, social science, would that change anything in the argument?
If you take seriously the prerequisites for forming a suspect class, it would change. And by the way, I'm not a scientist too, Bill, but this reminds me of the age-old debate between nature and nurture.
Yeah, sure.
And it's exactly right. Sometimes it's all nature, and sometimes it's all nurture, but for many people it's both.
Yeah, it's in between. Yeah, exactly right. Let's go to Rich in Orlando. I think we've dealt with this already, but it's a different turn on it. Go ahead, Rich.
Hi. I think this argument kind of dovetails with what you guys have been saying, but I've used this effectively against coworkers who are very pro-gay marriage. But I say, in effect, if you strip away the sacred and religious elements, let's leave that aside, then in effect you reduce it down to contract law, and then you open it up to anyone, any adults who want to enter into a contract, whether it be a brother and a sister, a grandmother and a grandson. They would have to be allowed to have those same rights. And when you frame it that way, they always invariably say, no, that's wrong, because I don't think people so much feel that gay marriage is an equal institution, but they don't like the idea that gays somehow are being denied rights to enter into that kind of institution.
No,
okay, Rich.
You articulated the same concern that both Bill and I were discussing, and of course, very good question by Justice Sotomayor. Let me again say that if you have a political solution to gay marriage, which is always incremental, always subject to reversal, that concern is largely non-existent. The constitutional solution, the wrong way, that concern cannot be dealt with. One important thing, because, look, we have a lot of cases, of course, with Lawrence v. Kansas having to do with striking down the laws banning consensual sodomy and a variety of other areas where, individual liberty is viewed as trumping everything. What's important here to understand is this. We're not talking about individual acts in their sort of private sphere. Marriage is quintessentially a societal institution. Remember, you could not marry privately. People forget that. You need to have witnesses. Marriage involves approbation of society. So when people say, I want a right to marry, what they're really doing is they're seeking the right to change same-sex marriage, change the institution, which was not an issue in all those other cases.
Right. You even need a witness in those wedding chapels in Reno and Vegas, right?
Yeah. No, you do, because, again, private marriage, because of a variety of obvious reasons. This was a public union. This was not a private matter.
Got it. We'll be back. David Rivkin, one more segment. Think about your questions and phone them in. Morning in America. David Rivkin stays with us, partner at Baker Hostetler, served in the Justice Department and in the White House counsel's office in Reagan and George H.W. Bush administrations. I want to play some more audio from the court yesterday. It's our last segment today with David Rivkin, but he has very cordially agreed to come back tomorrow because there's another day of hearings today on the DOMA aspect of this. But first, Mike in Jacksonville. I think I can piggyback on Mike, too. Go ahead, Mike. You're on with David Rivkin.
Oh, wow. I'm excited to be on with you, Dr. Bennett and Mr. Rivkin.
Thank you.
I am a longtime Republican and fairly fiscally conservative, but when it comes to social issues, I feel very libertarian, particularly about this one. How is it constitutional to deny, say, a marriage license to one group of people and allow other people to have it?
Okay.
The answer is very simple. Aside from the issues that are clearly taken off the table by the Constitution and not subject to majority control, we're a republic, we're a democracy, we're not driven 100% by the Constitution. All other issues get done through the majoritarian political processes, and all sorts of arrangements are blessed at the state level when states exercise police power that, frankly, have much less compelling force in them than traditional marriage, just because of moral considerations. And one thing, it's an excellent question. I've been debating it with a number of libertarian friends who kept talking to me, what about liberty? What about liberty? And I tell them that they have a very crap definition of liberty. The right to indulge yourself, indulge your whims, uncabined by any restrictions, robs you of being a viable participant in the political process. Because remember, the restrictions are imposed on you by people from Mars, imposed by you by other citizens, including you, participating in the political process. So there are two aspects to liberty. One is purely individual, kind of anarchical liberty, and the other one is liberty to shape your environment, to shape the society you live in. And I'll tell you what I tell my libertarian friends at Cato and other places. You rob yourself of an important aspect of your liberty, one aspect of your liberty to satisfy unlimited aggrandizement, other aspects of your liberty, and it's not a good thing for you because we're social animals. The reason we don't live in the state of nature, aside from practical reasons, is because we want to shape not just our personal lives. We want to shape society. You go down the path you're suggesting, there will be no shaping. Everybody would do whatever the heck he or she wants. That's not going to be a good society.
Why isn't the answer simpler? Why isn't the answer, Mike says, grant marriage license to some and not others? Well, we already decide not to grant marriage licenses to all sorts of people, brothers and sisters, minors, relatives, polyamorous relationships, polygamous relationships. It's not as if anyone ever thought or acted as if this were an absolute.
Oh, no, I agree, and that's a narrow answer that we
it is a narrow answer, right.
Earlier about the sanctity of marriage, the vibe, again, preservation of marriage institution, but I was trying to give also a broad answer because I had a number of good libertarian friends ask me more or less the same question. Well, if I really feel strongly that I want the blessing for this contract, for this arrangement, why shouldn't I get it? That my liberty is being trampled, and that's the reason I try to deduce a broad answer. We basically says if you do it, you shoot yourself in the foot.
Okay. Let's quickly play cut 4. I just want to get, as a scholar, David Rivkin wants something to say about this. Scalia's challenge to Olson. Quickly, guys.
When did it become unconstitutional to prohibit gays from marrying?
Then they did not assign a date to it, Justice Scalia, as you know. What the court decided is a case that came before.
I'm not talking about the California Supreme Court. I'm talking about your argument. You say it is now unconstitutional.
Yes.
Was it always unconstitutional?
It was constitutional when we, as a culture, determined that sexual orientation is a characteristic of individuals that they cannot control.
I see. When did that happen?
There's no specific date in time. This is an evolution.
How am I supposed to know how to decide a case?
Because the case
you can't give me a date when the Constitution changes.
All right, David. You got a minute and a half.
Excellent question, and of course a bad answer by Ted. I mean, look, one of the reasons Justice Scalia is things driving yet, the court as recently as 1972 in a case called Baker versus Nelson refused to even entertain a challenge to a Minnesota Supreme Court decision that held that gay marriage was not allowed. Said there's no significant federal question. But a broader point here is this, again, what is driving the proponents of that view? That how robust, how sturdy is a conclusion that sexual orientation is indeed genetically imprinted? How robust is a conclusion that gay people are facing this odious discrimination? So Scalia was having a little bit of fun there, and again, not a good answer by Olson.
All right. We'll leave it there for today. David, you'll be back tomorrow. Thank you so much. You really shed a lot of light for us and helped us understand it. Thank you.